I'm currently in the UK on a skilled worker visa, but my job doesn't meet the new RQF Level 6 requirement. Will I be forced to leave? Let's dive into this pressing question. But first, some important context. The UK's immigration framework has undergone a major transformation. Following the publication of a sweeping immigration white paper in May 2025, the government began implementing substantial changes on July 2 to ND. At the heart of these reforms is a shift toward a more selective immigration policy, one that emphasizes higher skill levels and higher salaries, with the broader aim of reducing net migration and encouraging investment in the UK's domestic workforce. These adjustments have understandably raised concerns among visa holders, employers, and families across the country. So in this video, we'll walk through some of the most frequently asked questions, offering clear, factual, and up-to-date answers to help you navigate this period of transition with confidence. If you haven't already, be sure to subscribe and enable notifications so you don't miss any future updates. Let's begin with the most important question. Question 1. What are the main changes to the skilled worker visa as of July 22, 2025? On that date, to significant updates came into force. The skill level for sponsorship has been raised. Previously, roles at our QF Level 3, roughly equivalent to A-level qualifications, were eligible. That threshold has now been lifted to our QF Level 6, which is equivalent to a bachelor's degree. This change has rendered about 180 roles ineligible for sponsorship under the skilled worker route, a strategic move designed to attract higher educated and more specialized workers. The salary threshold has increased. The general minimum salary for skilled worker applicants rose from £38,700 to £41,700 per year. Employers must now pay whichever is higher, the new general salary requirement or the updated going rate for the specific job. Question 2. I'm already living in the UK on a skilled worker visa in a role that no longer meets the new RQF Level 6 requirement. Do I need to leave? The short answer is no, you don't. If you were granted permission under the skilled worker route before July 22, 2025, transitional measures have been put in place to protect your status. These provisions allow you to remain in your current role, even if it falls below the new RQF Level 6 threshold. Apply for extensions of your existing visa, change employers, or move into another job that is also below our QF Level 6, provided it's still eligible under the transitional terms. Bring dependents with you, assuming you continue to meet the required salary thresholds specific to your occupation. In short, your current visa isn't suddenly invalid. You're protected under the earlier rules. At least for now, these changes mark a significant pivot in UK immigration policy, and while they aim to raise the overall skill level of incoming workers, those already within the system are not being pushed out unfairly. We'll continue to monitor development closely and bring you the latest as soon as new guidance or clarifications are released. If you found this information helpful, drop a like, leave your questions in the comments, and don't forget to subscribe for more trusted immigration updates. First, it's important to understand that this isn't a path to permanent residency. If your application is successful, you'll be granted entry clearance to the UK for a maximum period of 3 months. This short window is not intended for work or study. In fact, both are explicitly prohibited. Instead, it provides applicants with a temporary period to consider legal options for regularizing their stay in the UK through other immigration routes. The system follows a two-step structure. The first stage involves submitting what's called an expression of interest, your way of notifying authorities that you wish to be considered. But there's a catch. These expressions can only be submitted during specific windows announced by the Home Secretary. If you miss that window, your submission is automatically rejected. If your expression of interest is selected based on the Home Office prioritization criteria, you then move on to Stage 2, the formal entry clearance application. In this stage, the Home Office itself completes the application on your behalf. and it's assessed against the scheme's eligibility and suitability requirements. It's worth noting that the UK government has intentionally given itself broad flexibility in managing this scheme. The Home Office can pause the process at any time to review applicant numbers, and the scheme will officially close once the target number matching the agreed number of returns to France has been reached. This is a highly targeted, temporary pilot program, not a new visa category. It establishes a clear exchange mechanism. For every individual returned to France after crossing the channel irregularly, a corresponding person will be accepted into the UK through this formal route. However, the permission granted is strictly limited to a 3-month stay and does not offer a route to settlement. What's happening with the proposed changes to the 10-year indefinite leave to remain ILR pathway? Has the government finally released the clarification that so many have been waiting for? If you're currently working in the UK under a health and care worker visa for a social care position, here's what you need to know. Your visa remains fully valid, and you'll still be eligible to apply for extensions. The minimum salary threshold applicable to most holders, those on national pay scales, continues to be set at £25,000 or the appropriate pay scale rate for your role, whichever is higher. But there's one major change that took effect in March 2024. Care workers can no longer bring dependent family members, that includes partners and children, to join them in the UK. This restriction is still in force, and there are currently no indications of it being lifted. Indefinite leave to remain the path ahead now. Let's turn to the topic that's been generating a lot of discussion: indefinite leave to remain ILR. Has the timeline to qualify really doubled? The answer is not yet, but it's in the pipeline. Under proposals outlined in the May 2025 white paper, the government has expressed its intention to extend the standard ILR qualifying period from 5 years to 10 years. While this change hasn't been enshrined in law just yet, the proposal would apply to the majority of work visa routes. Importantly, it's not expected to impact family visa categories. Could there still be a shortcut to settlement? Yes, potentially. Alongside the proposed 10-year route, the government is considering a new earned settlement system. Under this framework, individuals who make notable contributions to the UK's economy or society could qualify for permanent residency in under 10 years. The details, however, remain vague. The government has yet to clarify how applicants would earn points or how much faster they might reach settlement under this scheme. For now, it's a concept, not a confirmed route. What if I'm already on the 5-year path to settlement? That's one of the biggest unanswered questions. If the 10-year rule does come into force, will it apply retrospectively to people already working toward ILR on the current 5-year track? The government hasn't given a clear answer yet. While immigration changes in the UK are typically not retroactive, we'll have to wait for formal guidance to know for certain. Until then, anyone already on the 5-year path should stay alert to official updates. Beyond the ILR changes, there are several other important shifts in the UK immigration landscape. Dependent rules for lower-skilled roles, new applicants taking up positions on the temporary shortage list at our QF levels 3 to 5 will no longer be able to bring dependents. However, this does not affect current visa holders or those working in RQF Level 6 or higher roles. English language requirements. The required English proficiency level for skilled worker visas will increase from B1 to B2. Dependents may also be required to demonstrate a basic level of English in future applications. Immigration Skills Charge (ISC). Employers will soon face higher fees for each sponsored worker under the ISC, though the specific increase has not yet been finalized. Graduate visa duration. The length of the graduate visa is being shortened from 2 years to 18 months, marking a significant shift for international students planning their post-study stay. The UK's immigration policies are undergoing some of the most significant reforms in recent years, with the government focused on controlling migration numbers and prioritizing higher-skilled and better-paid roles. Both employers and applicants must adapt to a rapidly changing system. The latest wave of changes, effective from July 22, 2025, has already reshaped the skilled worker route and beyond. Looking ahead, Proposals like the extended settlement period suggest even tighter regulations could be on the way. For anyone affected by these shifts, the key is to stay informed. Keep an eye on updates from official government channels, and don't hesitate to seek expert immigration advice. These rules are evolving, and understanding the fine print could make all the difference.